You shut down Google if you need to shut down Google.
Welcome back. If you're new or missed some videos, please click over to the Rockingham County series playlist to get caught up. We are going to cover a lot of ground as we head into the appeals. Before we jump in, I want to remind you all that we are not giving you legal advice. We are simply explaining what we have gleaned from research and experience. First up is what to do when your request for reasonable accommodation is denied in North Carolina. Is there a process to get that reviewed administratively?
It's supposed to go to a disability access coordinator, who is an administrator, not a judicial personnel. They're not a prosecutor. They're not an attorney. They're not a judge. And this administrator is supposed to review the request and the response and figure out if it was reasonable and then support the decision or not. If you go to the North Carolina Administrative Offices of the Court, NCAOC, if you go to the website, they have it on their website, like this procedure on quote unquote due process for a person with a disability that is asking the courts for an accommodation. And first is you make the request to court personnel. Then you wait for a response. You can make it in person. You can make it over the phone, right? And then you get a response. If they deny your request, what do? Then they lay that out. Well, if you get a denial, then you're supposed to write or call or contact the DAC, Disability Access Coordinator in Raleigh, and let them know, hey, I'm appealing this denial, right? So you spell that out for them. Now, it doesn't say how long they have to review this. It doesn't say who exactly is going to review it. It doesn't say their criteria of review. It doesn't say if what they're looking at, if they're looking at the ADA, Section 504, current case law. It doesn't say any of that. So I would argue that on its face, this system that they have set up claiming to have administrative due process is incomplete because one, there's not a timeline, and two, it doesn't specifically lay out the criteria for review. The third step for that is if at that second level, they don't sustain your allegation, they affirm your denial, then you can appeal that to their director, and again, administrative director in Raleigh. I think it just says director. Like, so who specifically is that? What are their qualifications? What kind of review are they doing? None of that is spelled out. But there is a timeline on this. That's the only place where you have a timeline, and that one is a 30-day one. But we don't know for that first level review, there is no timeline. For us, it's taken months or years, I think, for some of those, for them to get that first level review done. And it's only because we reminded them, like, hey, I put in this appeal months ago or years ago. And then they go, oh, okay. And then like the next day we get a response. Yeah, denied.
Remember, these are requests for equal access just to get in the building.
Right.
So you've got a court date coming up and the courts are like, you have to be here or else.
Right. You have to be here Monday. And you're
right.
doing the denial is on Friday.
Right. You're like, and so you send these emergency messages. Hey, this is an emergency. I'm supposed to be in court on Monday. And they have made no accommodations.
And there's no window. There's no timeline to have this appeal done. If you put in an appeal to be heard on your accessing court with disabilities, there's no process in place saying that they must inform the court, the clerk, the trial court coordinator, the prosecutor, the judge, and say, hey, you need to stay proceedings. You need to wait until we get this resolved.
Right.
That's not on there anywhere, right?
Yeah,
because how it actually happens in practice is not how they have it on paper. I would argue that in paper, they don't even have procedural due process because we don't have a timeline. We don't have specifics about what the nature of the review is. None of that's there, right? Now, in practice, the substantive due process also is lacking on the administrative side, because what happens is you make the request to any court personnel, and a lot of times, and we've proven this on the channel with videos and audio, they don't know what an ADA request is. They don't know what a disability coordinator is or a disability access coordinator. So they're forcing the person with a disability to know these things and to invoke those special names and special words, right? Yours is whoever, and contact this person, call them, get them here, have them talk to me because you don't know how to process this. So they're forcing that obligation, that onus upon the public with disabilities, when the law puts it on every entity. The American with Disabilities Act requires that each entity take affirmative action. They have the duty to be looking if somebody has a disability. If they are making a request, recognize it as a request because of disability and then treat it accordingly. So how it actually happens in practice, I make the request. it gets passed up because I say you need to take this to the DAC, or I get the DAC's information and I make it directly to them on the phone or on the email. And then they in turn take it and immediately go to a judge.
Yep.
They don't follow any protocol. They take it straight to a judge. Some states have it written out in their policies where judge is acting in an administrative capacity, and they'll do the review, and then they'll have that dialogue with the person with the disability in an administrative setting, email, phone call, informal, not in a courtroom, right? Not invoking any judicial power, just as an administrator. And then a judge can then come to that conclusion as an administrator. Here's the accommodation we're going to make or not make, right? But in North Carolina, the judge is nowhere in that procedure that they have listed. Instead, this is what they do in practice. In practice, they take it, they give it to a judge. The judge then pulls it into the courtroom, puts on their special dress, and puts it in an order, trying to force it into the judicial realm, where they can have more power and control over the situation. Albright did this in Rockingham County case first, and he made this whole 2-page, 3-page, I don't know, document, judicial order, all about the ADA request that I made, and him denying, granting some things like my glasses, my white cane, right? But then denying like all this other stuff, and basically saying it's impossible, right? As soon as that judge's order came out, I not only appealed it the administrative way through the DACs, but since we had an order from a judge in the judicial realm, I also appealed it through the judicial channel. So the response we got back from the administrative side months or years later was through that full review process, was them saying, we can't do anything because the judge ruled. We literally have the emails in their official response saying, once a judge does something, we're powerless to review it and overturn it or say anything differently. So they're admitting officially there is no substantive administrative due process if a person with a disability in North Carolina requests an accommodation to access courts.
So if the NCAOC won't touch the issue when a judge has made a determination, what do? The only other option was to try to appeal the administrative civil issue to a higher court. In order to appeal a criminal matter in North Carolina, the matter must be concluded. For example, if you believe you are being falsely prosecuted, you must first suffer the harm of being prosecuted. Once the matter is adjudicated, you may appeal. In Mike's case, the issues he appealed were not the criminal charges. While the criminal charge is a major issue, and Mike is continually harmed by the malicious prosecution of a frivolous charge that is still being pursued by the prosecutor over 4.5 years later, that issue was and is not currently up for appeal. The rulings that Mike appealed are specifically regarding the rulings the judge made denying Mike equal access to the courts and thereby ordering that Mike not be allowed due process. Mike appealed to the higher courts to step in and correct the lower court judge's error and to allow Mike equal access and due process as he continues to try to dispense with this case. Without equal access, there is no due process. Mike filed his notice of appeal to the Rockingham Superior Court on February 3, 2022, informing them and the prosecution of the pending appeal. Mike then had to get access to the North Carolina Court of Appeals. Remember, Mike is blind and requires accommodations to facilitate equal access. First hurdle, sending and receiving all court documents and communications digitally rather than via physical mail. Mike called the NC Court of Appeals, NCCOA, and spoke with the Disability Access Coordinator, DAC, to get started. That first phone call did not go well and devolved into the DAC yelling at the disabled veteran over the phone and denying accommodations outright rather than working with Mike to facilitate access. Mike reached out to the DAC at the NC Administrative Offices of the Courts, NCAOC, for assistance and to inform them of what transpired so they could help correct the clearly uninformed DAC at the NCCOA. Thankfully, that correction went fairly smoothly, and Mike and the DAC were able to work through the issue and get Mike access. Yay for forward progression. Up next was putting together the record for the appeal and getting permission from the Court of Appeals to submit the audio recording that Mike received from the clerk of court in lieu of an official transcript. Typically, if a higher court reviews a lower court, they are relying solely on words on a page or screen. If you haven't already, go back to Part 11, or any of the breakdowns of that hearing, and listen to how that judge constantly repaints the narrative from what is actually happening in the courtroom to what he wants to have on the black and white transcript. Anytime he interrupts Mike or talks over someone, anytime he raises his voice or misspeaks, He knows that the court reporter will go over the recording with a fine-tooth comb and smooth out all the rough spots. The judge makes corrections to the record throughout, and she honors those. That said, Mike did not have access to the official typed transcript, but did have the audio. This audio would allow the Court of Appeals judges the opportunity to view court the way Mike did and allow them to hear the disdain in the judge's voice and the many, many times the judge talked over Mike or others. It would grant the court a more clear understanding of what transpired. Mrs. Nelson did type up an unofficial transcript to highlight some of the key areas that Mike was specifically appealing. Mrs. Nelson tried to be clear with what was happening in the court. If the judge interrupted Mike, she typed, "Judge interrupted," and then what he said. Mike submitted the proposed record and a motion for leave to file audio recording on March 9, 2022. On March 11th, the Court of Appeals granted the request. The prosecutor didn't like that and submitted an objection after the deadline had passed. Interestingly, the prosecutor took issue with Mrs. Nelson making note of when the judge interrupted, even though it was clearly recorded in the audio. In every circuit in the U.S., the appellate courts hold that they defer more to the lower court judge's opinion because the lower court judges were physically present in court and could see and hear what was actually said and done in the courtroom, whereas the appellate court has to rely solely on a cold transcript. This highlights Mike's argument that the visual information is vital in court. It's the same holding in every circuit, also demonstrated by the prosecution trying to block the allowance of the audio recording itself because it shows all the interruptions and disdain of the sitting Judge Albright. Let's listen in as Mike offers a quick rundown of how far he pushed this appeal.
I appealed Judge Stuart Albright's administrative order. It's a judicial order. It's a civil order, but I did it through the admin side. It got nowhere. They said they're powerless when a judge does it. So then it's like, let's do it through the judicial side. So he's at the Superior Court level. So I appealed it to the North Carolina Court of Appeals. The Attorney General's office for North Carolina jumped in as the opposition. Now, it was no longer the local prosecutor. Now I was going against the North Carolina Attorney General's office. They put in a response. They said he doesn't have a right to appeal because this comes out of a criminal case and there hasn't been a final dispensation of the case. We don't have a judgment whether he's guilty or not guilty yet. It hasn't been dismissed. Therefore, he has no statutory right to appeal. This is their argument. They didn't want to deal with the issue at hand of the Sixth Amendment violation, the 14th Amendment violation, the 80th. They didn't want to deal with the law at all in it. I responded. I think they may have in some back and forth filings. You can find it online if you guys want. Essentially, the North Carolina Court of Appeals dismissed my appeal, right? Because the Attorney General's office put in a motion to dismiss the appeal on the reasons I just gave. And so they said, okay, yeah, dismissed. That's all we have from them is just them saying it's dismissed. So then I appealed that decision to the North Carolina Supreme Court. I think the Attorney General of North Carolina, they kept their same arguments from before, like he doesn't have a right to it. But they also said that there wasn't a constitutional issue. They wanted to wave it away and say, no, this thing he's bringing up, there's no constitutional issue at play.
Jedi mind tricks.
Yeah.
Nothing to see here.
Right. And so I was arguing the contrary. I was arguing, no, the Sixth Amendment says that you have a right to access court and face your accusers, right? And if I have to go in and I can't take notes and I can't see my accusers in any way with any of my assistive technology, then am I actually facing my accusers? I would argue, no, I'm not. I don't have access to any of this information, any of the visual evidence that you want to present against me. I don't have access to it. So that's the Sixth Amendment issue that I was bringing. And then the 14th Amendment issue I was bringing was the due process issue. Like, hey, they're trying to force me into court and punishing me for not accepting the unequal access that they were offering, right? And so that's the 14th Amendment due process issue, but also equal protections issue. The North Carolina Supreme Court agreed with the North Carolina Attorney General's office, and they simply said, like in one line, there is no constitutional issue here. So they denied my appeal, essentially. I appealed their decision. I appealed the North Carolina Supreme Court and went all the way to the United States Supreme Court, the SCOTUS. And when you do that, you put in, it's a petition for a writ of certiorari. So essentially you're asking for special permission for the U.S. Supreme Court to hear your case. And the U.S. Supreme Court takes maybe 1% of the cases that are petitioned for them to take, and they didn't take my case. So I think it only took them like a month or two.
Yeah, it was actually pretty fast.
Yeah.
For court.
And then they came back and denied to hear my case. So they didn't even hear my case. So so what's the point? Well, we proved there is no administrative due process, that I didn't have the opportunity to be heard through the administrative process. There's no substance there. We showed you there's no first process there. The actual procedure doesn't lay out a time frame or who does what specifically. And then the judicial side, through the state courts, we gave them a chance at every level to give me the opportunity to be heard and make my case, and for the other side to make their case. And they refused to hear it at the Court of Appeals, essentially refused to hear it at the North Carolina Supreme Court and at the U.S. Supreme Court. So no due process administratively or judicially.
No court ruled against Mike or corrected the judge. They simply looked the other way, turning a blind eye to the plight of the disabled. Cowardly, all. Where is justice? Well, we are still here and we are still fighting. Remember, the criminal case is still ongoing. Just this year, 2024, a Superior Court Judge Harding denied Mike access to court, again, revoked the $50,000 cash-only bond that Mike's wife took out a loan to cover and is still paying off, issued an arrest warrant and raised the bond to $100,000. Stick around for more on that in the next video.
Thanks for watching. Deo presso, liber.